Hello, this is Moji from the Feminist Buzzkills crew, and I am really excited because we are about to go on live with Chris Geidner from LAW Dork and talk about, we've been so excited and so stressed and, just worried about these elections that happened yesterday that ended spectacularly. And while we were busy, it seemed that some attorneys general had member, but there's an update, and so Chris is going to come and talk to us about this update and this new development by any media outlet. I know, I looked. Hey, Liz. How you
Hey,
doing?
good. How are you?
I'm doing pretty great. It's been a day.
Awesome. Yeah, it's been quite a day. You like party for 5 seconds with good news,
Mhm.
and then your good old friend Law Dork is digging around and rooting around in the facts,
Paying
and then
attention.
paying attention. He literally dropped me um, a note, a PM, being like, "Hey, this happened, and there's a lot of stuff going on, and I don't know if you saw this." And we'll talk about it when he comes on, but you kind of preface it by saying there's some fuckery happening with the worst attorneys general in our all United States,
Not the worst. We
trying.
know the worst,
I
Liz.
mean, your boyfriend is the worst. And I see Chris has joined, so maybe
Yeah,
we can
he's
invite him
joined
on in a hot second.
us.
But just wanting to be, I guess it's the party that won't end, this Alliance for Hippocratic Medicine VFDA case, and everybody wants to be part of it. And we have so many questions about why these attorneys general want to be part of it. Like, what's the buy-in? What are they worried about that they want to insert themselves into the shit? Hey,
What
Chris,
do they know?
request for us to join, and we'll have you pop on, because I can't remember how to do it any
I
other
can't either.
way.
I never can.
I'm an
I'm like,
idiot.
oh, yeah, please, Chris, just ask and I'll take care of it. But yeah, I want to know too, like, what do they know that we don't know? I mean, when we're talking about the worst attorney general, yes, Mallory, we are talking about Daniel Cameron. I
But
love to hate
he's
him.
not part of the truth.
No.
It's Ashcroft from Missouri. It's Raul Labrador from Idaho, and
Chris
Chris
Colbert.
Kobash from
Yes.
Kansas. So we could call them the trilogy of
We
terror.
can.
Uh,
And wait, here comes
all
Chris.
right.
Hold on. You'd feel like I'd know how to let people in lives by now, and yet, and
And
yet.
yet,
Hi, Chris.
yes. Oh,
Hello.
How
hi,
are
gosh.
you?
Can I just say, first of all, Chris is one of the first people that I met on Twitter, and we became internet friends. And now you have made all the things that we're doing so digestible. You're
Mm-hmm.
so brilliant. If you are not subscribed to and paying for Law Dork on Substack, you got to do it, because you're just smarter for it. I cannot tell you how much I love it and how much I rely on it. And I'm so excited to talk to you
Thank
today.
So
you
excited.
so much. Yeah, it's been quite a while since the
Since we've
the
hung.
innocent early days of the 2009
Oh,
Twitter.
those are the halcyon days of Twitter. It was such good
Such
times.
halcyon. Halcyon.
They
Chris,
were
this is
something.
Moji. This
Hi,
is Moji, my
Chris.
co-host and podcast.
Hi.
Also, congratulations on your fine state of
Ah,
Ohio.
we're
Has
so
Yes.
been good.
excited.
What a
Yes.
day.
What a
What a
day.
It
day.
was quite a day on
Oh
Tuesday.
my
Not
gosh.
I think what we were expecting.
It was not
But
I did not expect a shellacking,
That's
if I might.
right.
exactly what was
I mean,
surprising, the
I
shellacking.
did sort of think that was going to be the result in Ohio, but I didn't think it was going to be that much. And then the fact that just sort of every state in which this was an issue
Or
just
or even not an issue, just like gestured at loosely. You know what I mean? Like in Kentucky, it wasn't an issue. They were just gesturing loosely at abortion, and they were
yeah.
like, "Yes."
I know. It's so true. So, Chris, our viewers and listeners We've been following this case since it was filed back in November of 2022 and the twists and turns that it has taken. And when you PM'd me and said there's a new wrinkle with these three attorneys general, and then even I usually understand everything in your explainers. Even I was like, Chris has explained this to me in the plainest of ways possible, and I simply need him to lay it out. So before we get to the new wrinkle, would you just kind of lay out for folks what this case is and why it all started?
Yeah.
And then we'll get to the what's happening now.
I mean, and this is sort of the thing. I mean, this is, and I do say that, like, I mean, this is becoming a like final law exam fact pattern. Like it's sort of like not even a final course, but like this could be the exam to graduate from law school, because it's sort of, it's got constitutional issues, it's got administrative state procedural issues, it's got civil procedure issues, it's got federal court issues. Like it truly is, like, it's something that, like, honestly, you have to really kind of hate your life to have taken the time to understand this.
It makes me
thank
feel
you for
like,
doing. As I
yes.
said, thank you for doing the work for us, Chris.
Well, and I will tell you, I mean, just so you know, like, I mean, this was, so, I mean, like, where we're at, to fast forward, where we were at this week was so unusual that even those of us, I don't want to name people because I don't know if they want to admit that they didn't know what was going on, but like even names you would recognize as being quoted regularly and talking regularly about this case, on Monday, when we like saw this filing, we were all talking to each other being like, so what does this mean? What will this actually lead to? Where did this come from? And so like, you are not alone. But so what this case is, it is, I mean, it really is ridiculous. So back in the Clinton administration, we only have 15 minutes. So like, let's pull back here. So quickly, I mean, back in the Clinton administration, they gave FDA approval to Mifepristone. And that's where we've been. And then that's one of the two drugs used in medication abortion. And starting in 2016, the FDA, having had it in use for 15 years, was like, you know, some of these limits that make it really hard for people to access this drug don't actually need to be in place. We don't need this many visits to the doctor. We don't need this much time. It turns out it's safe after this point and not just before this point. Those changes were made in 2016. Then as the pandemic began, the Biden, that was under the Obama administration. Now, it is important to note, you might remember there were some Republican presidents in between these various things, and they never removed it. They never, when Clinton left office and George W. Bush was in office for 8 years, they didn't change this. Then Obama gets in office, they make they loosen these restrictions. And then Trump comes into office, he doesn't change it. Then Biden comes into office, we're in the pandemic, and they get rid of the ban, or what they get rid of is the requirement that there be in-person dispensing. And so you're now able to mail Mifepristone. Now, those are the changes. In the background, there had been what's called citizen petition challenges, that basically anybody can go, like with most things, can go to government and say, we think you screwed up. And they had done that with the original approval of Mifepristone, but they didn't take all of the steps that you could take to actually move that forward when they didn't get an answer. And that kept going, and eventually you got to this loss, and they filed a citizen petition with the 2016 changes. Then they filed a petition for the 2021 changes. And all of that comes into this lawsuit in 2022. And what they were claiming is, we want to go all the way back to the 2000 approval. We want to say that's not allowed. We want to say that the FDA didn't have the authority to do it under what was called Subpart H, which allowed for quick approval of drugs. They wanted to say that the 2016 changes were not allowed, that the FDA didn't have the authority, that they didn't use the proper, it was what the term in administrative law, it was an arbitrary and capricious decision. And because they didn't have enough studies about those changes. Now keep in mind that that's not the sort of stuff that we get into in reviewing what the FDA does.
Right.
We don't dig that deep because they're the FDA.
Right.
Like, unless there's evidence that they got it wrong, looking at the right studies, did you do this the right way? And so,
hey, Chris,
and then
before
they said,
before you go on, I just want to remind people that this drug was approved in Europe in 1988, approved here. Since its first approval until now, over 5 million people have safely and effectively used this drug, with the count that I read research recently, around 25 relational to death instances. So this is a drug that has been around for a really long time, and so carry on.
And is incredibly safe.
Yeah, and that's the reasons for the changes that they made in 2016. Like the argument from these challengers are basically like, well, you didn't do all of these things together in a study with randomized trials and blah, blah, blah. And like, that's not how medicine works when you already have drugs approved. Right. Now, we're also dealing with this. I'm also dealing with this a lot in these trans ban cases too, where they're saying, well, the FDA didn't give a particular approval for these hormone drugs for gender affirming care. And it's like, well, that's not how the FDA works with drug approval. Once they've given initial approval to drugs, off-label prescribing is very, very common and not disallowed. So you've got this litigation that starts, and it is there's this little trick that the Republicans are playing, where the way that district courts in Texas are set up, there are some divisions within the districts that basically only have one judge. And Matt Kaczmarek gets something like 85% of cases that are filed in that division, the Amarillo division. And the other judge isn't much better, just to be clear. Like, it's not like there's a 1 in 8 chance of getting a good judge. Yeah. So Kaczmarek gets this case, and we all knew it would be bad, and yet it honestly, his decision was worse than we thought it would be. First of all, if you remember back, like, once everybody realized the hearing was going to be coming up, like, he tried to have it like secret.
Yep.
And like,
he wouldn't tell media when it was happening.
Yeah, like the Washington Post found out about it like on a Saturday night. I then went through all of his court rules and found out that he actually had like this thing in his court rules about the importance of an open courtroom. And I sort of stuck it to him there. And he did open up the courtroom. And so we were able to have reporters there. Luckily, people who actually have money, not LAW Dork. But there's another plug. Subscribe, paid subscription. So he ended up issuing this ruling on April 7th, I think it was, April 7th or 8th, that went as far as it possibly could have gone. Now, one thing to note, this case was brought by, backed by Alliance Defending Freedom, by Josh Hawley's wife. Erin Hawley is the main lawyer arguing this case. It's this far right case brought to this far right judge asking for an unprecedented result of pulling a drug off the market that's been on the market for 20 years. And he said yes. He granted them all of the relief they wanted. He also rejected the DOJ argument that even if you agree with them, what you should do is just put this ruling on hold while it's appealed. And he said that he was going to stay the approval of the drug, which basically would have put the approval on hold. So the approval would not exist. And he said that as to the 2000 approval. He also said it as to the 2016 and 21 changes. That goes into the warm embrace of the Fifth Circuit Court of Appeals, the most conservative of the conservative appeals courts. And this is actually pretty amazing. They decided that he went a little too far even for them.
That is so wild. That was so wild.
Now, it is a little trick that the Fifth Circuit is trying. There's a game playing way that you can look at this, where these district court judges issue absolutely lawless rulings that have no basis in precedent and precedent, history, anything. And then it goes to the Fifth Circuit and they pull back the most extreme part of it, but still leave things that are clearly unprecedented, and say,
Chris,
look, we're reasonable.
When I wrote for The Daily Show, we used to submit jokes to the network that we knew they would never approve because they were so fucked up, so that we could
so
get
you
the
could
joke
keep
on that
the
we
ones you wanted.
Yes.
Yeah, that's the perfect explanation of this. And so what they do, the Fifth Circuit says, we're going to put the part of his ruling on hold that would stay the 2000 approval. So we'll allow Mifepristone to remain approved, but we're going to keep those two other parts of his ruling in place. So the big effect, they would have ended male prescription of Mifepristone. They also would have moved back the time limit in gestation that you would be able to prescribe Mifepristone.
Yeah, from 10 weeks to 7 weeks.
They would have required the additional doctor, it was two doctor visits.
Yeah.
So it's essentially a 7-week ban on abortion.
Basically.
That would be nationwide.
That then goes up to the Supreme Court, this Supreme Court, and they put the whole thing on hold while they're hearing an appeal. They say, whoa, Kaczmarek. Whoa, Fifth Circuit. Of course, Alito and Thomas say, well, we're not sure about this. But those were the only dissents. So we don't know the vote. We know at least 5 justices, but we only know that 2 were willing to say
this is
that they
fine.
would have allowed the Fifth Circuit ruling to go into effect. And it was sort of open-ended because it was until the Supreme Court can review an appeal. So
that's where we've been. Right?
We've been there for months.
Waiting.
We've been there. The Fifth Circuit ended up issuing a merits ruling on the preliminary injunction, which was basically the same. They said the 2000 approval is untimely. You can't challenge that. But they said the 2016 and 2021s are likely impermissible. That then a cert petition is filed by the Justice Department.
Tell people
and
what that is, a cert petition.
That is asking the Supreme Court to hear the appeal. Okay. The Supreme Court has discretionary review. They have very few cases they have to take. It's basically only cases when states are suing each other. But in other cases, they almost always have discretionary review, and that's called a cert petition. So DOJ and Danko file that. Incidentally, the challengers also file a cert petition saying, if you take the case, we want you to hear a case over the 2000 approval itself too. So that's all up at the Supreme Court. They're supposed to be filing their responses on all sides over the next week. Then we get to last Friday.
Yeah, what the fuck?
And
I was like, oh, yeah, like, what's happening?
AGs from Missouri, Kansas, and Idaho.
Garbage AGs, garbage.
Yeah, I mean, Chris Kobach is the Kansas AG. You might remember from earlier absolutely batshit immigration policies.
Yep.
You might also remember from batshit Trump election fraud commission that even in the Trump era couldn't do anything and sort of dissipated into nothingness. He was like the co-chair of that. And then he ran for AG and is AG of Kansas. The AG of Missouri is also a bit of a dope. Andrew Bailey, he's appointed. He's never been elected to office. He was the general counsel of the Department of Corrections in Missouri, then became, that's a yikes. He then became the the appointed governor who ran for election, but remember there was all that the weird governor and so the appointed governor in Missouri who later ran for election and won appointed the AG, Andrew Bailey, who will have to run in 2024. So is doing all sorts of right-wing stuff so that he can not have a primary challenge. And then Raw Labrador in Idaho, I don't know what his deal is.
He was creepy in Congress.
Yes.
Yeah, I mean, he's been around a long time, so he's not necessarily like a new guy. I think he's just in a state where he thinks this plays well.
Well, Chris, what I can tell you about him is that he's very down to, he's the one who's super excited about this abortion trafficking situation in Idaho.
Well, he's that, and
he's so all for that, and he's really wants to prosecute anybody, anyway, anyhow.
He's also fighting at the Ninth Circuit over the emergency care lawsuit that DOJ brought against Idaho.
And Idaho is literally shutting down whole cloth OBGYN departments in hospitals because people won't practice there anymore. So that's Raw Labrador.
Total sense.
Yeah.
I mean, they're fighting this emergency. I mean, this very minimal emergency. I forget the initial EMTALA.
Yeah.
Where like you don't have many obligations, honestly. It was sort of like the least DOJ could do sort of thing. And even that Idaho is fighting. I mean, they're fighting the opposite of the Fifth Circuit. They're fighting in the Ninth Circuit to try to win.
All right, so talk
we've
about
got
what these three clowns are doing.
Yes.
They are, while these cert petitions are pending at the Supreme Court, down in Texas, they go to Matt Kaczmarek and say, we would like to intervene in this case.
What does that
mean?
Yes.
So here's the thing. Even though this case has been going on since November 2022, it was on preliminary rulings, preliminary injunction, preliminary order. While that was being appealed, Kaczmarek stayed the filing of an answer in the case. So there's not even a legal answer to the initial filing filed by DOJ yet.
So the
FDA
three courts, no ruling. Three courts, no ruling.
That is not like a weird Kaczmarek thing, to be clear. That happens because a lot of times if there is a case where we think it's going to be resolved on the law, there's no real debate over the facts, we don't need to go through discovery and evidence and depositions because we kind of agree. And so, like, you have preliminary motions, that's the preliminary injunction, where before you answer, before you go into all of the time of like getting ready for trial, you try to resolve the case through preliminary motions to dismiss, and that's where we're at. But so because he put this order in place, staying the need to file an answer, which DOJ probably said we want that too. Because of that, this motion to intervene from these AGs is probably going to be considered timely. And what they're saying is we have a similar issue. We're questioning the same things, and because their argument is because DOJ and Danko Laboratories, the makers of Mifepristone, are arguing at the Supreme Court that the big issue is that these anti-abortion medical associations that are suing don't have standing to bring this lawsuit. We have different standing arguments, different legal bases to bring a case to the court that we think you should allow us in this case as well in order to allow you to actually resolve these issues, because this is an important issue that we should be able to resolve. Now, of course, the obvious thing would be, ask your question.
Thank you, because I had a question too.
Yeah.
Go for it.
Do you think these three think that these anti-abortion doctors and a dentist, by the way, who thinks he has standing, don't have standing, and that they're fucking this up? Do you think that they're sliding in?
Well, one, that would just be right. I mean, the standing ruling from Kaczmarek was weak, but the standing ruling from the Fifth Circuit is just like lunacy. Like, to allow that to stand, like, would be like just it's so many rounds of speculation.
Yeah.
Like the whole thing, like the whole idea of standing is that you have a real interest you have a real injury with that your lawsuit could lead to a ruling from a court that could redress that injury, could solve that problem. This case doesn't do either end of that, because like, think about what these doctors are saying. They're saying that this approval could lead to medication abortions, that could lead to problems, that could lead to those people who have taken Mifepristone to need to go to a hospital, that could lead them to go to the hospital we're working in, that could lead to us being the only doctor who's there when they need treatment, that could lead to me needing to violate my conscience. So that's the number of levels. But here's the thing. Even if Mifepristone was taken off the market, we all know that, I can't say the other drug.
Misoprostol.
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 That there is a treatment regimen that could go forward, that medication abortions would continue even if you got rid of Mifepristone.
But also,
so therefore, just from that end, it doesn't even if you get past do they have an injury, the redressability, which is just as important to finding standing, doesn't change. Like, so it just doesn't change. And so, like, the standing is utterly ridiculous. So these AGs, like, there are lots of political, like, obviously this is a political move. The question is, what political move is it?
I think that's my question. Like, are they basically saying, okay, if these doctors can't do it, maybe we can?
That's part of it. There's also this question of maybe they just want to slow down the case.
Okay.
They don't want the Supreme Court to determine it this term, either because they do think it'll lose, at least on the 2000 measure. And so therefore they want to slow down, like, let's keep it from the Supreme Court this term and hope that the 2024 election goes well for us Republican AGs, and maybe then we'll be able to get a different ruling from a court in the next term. It also could just be a political move, like this, like the thing that I said about Bailey, that like it truly is a small picture, we're all politics is local sort of thing, that like we want a headline.
Right.
That they're not caring about the national implications of this, because I actually think that there's a scenario in which this is a good local politics, as in state politics for Bailey, Labrador, and Kobach, but not good politics nationally, because I think I think that Biden and Harris would love nothing more than to not get this resolved before 2024, if we think, which we do, that at least as to, like, this is a case where the odds are that John Roberts probably wants this case because he thinks that he can issue a ruling that will be, see, we meant it
Right.
in jobs, that we're going to be reasonable, and we just want to open this up to the process, and we're not like trying to take abortion away from everyone and blah, blah, blah. Like, I think that, and I mean, I think that's like this say that we got from the Supreme Court, like, was sort of an argument for that. And so in some ways, I think like holding this off might be good politics for Bailey and Kobach, but I don't know if national Republicans would agree with it. And I certainly don't think Trump, who is sort of afraid of abortion politics now, wants this to be front and center during the campaign.
So let me ask you this. So these three AGs have filed ostensibly for all the things you said. They think they have standing because they want to represent the people of their state, blah, blah, blah. So how does their trying to insert themselves, are they trying to jump onto the same case?
Yes, it's the same case. And some of the report, bluntly, some of the reporting elsewhere about that was bad on day one and was saying it was a new lawsuit. They have a proposed complaint that you file when you intervene in a case. And it would be a new complaint that would go, a new lawsuit that would go in the same case. They are asking for some different things. They do not, in their lawsuit, technically ask for the 2000 approval to be removed. However, they nonetheless say in their lawsuit that they think the 2000 approval was arbitrary and capricious, which, as we talked about, is the standard for overturning it. They say they use that, though, to challenge the generic approval, which is important because the Fifth Circuit, one of the, in addition to saying that the 2000 approval was untimely, they did say that the challengers in this original Mifepristone case didn't have standing to bring the generic challenge. So therefore, right now, from the Fifth Circuit's perspective, the only things that are in place are the 2016 ease of restrictions and the 2021 easing of restrictions are going to be taken back if the Fifth Circuit ruling were going to be in place. But the 2000 approval and the generic approval would remain.
So let me ask you this. So what, now that this new wrinkle has happened, what is the Supreme Court, I'm sorry, everything falls. What is the Supreme Court now considering?
This could really screw up the Supreme Court status of things, because they've got this petition. we are supposed to be getting the response briefs this week and next week. Each side, the medical associations, the anti-abortion medical associations, so Alliance Defending Freedom, is supposed to be filing their response to DOJ and Danko's cert petitions this week. And then DOJ and Danko are supposed to be responding to their cert petition next week.
Yep.
Now, this proposed intervention, which I did check the docket in Kaczmarek's case right before I got on, he's not done anything with it thus far. Normally there would be a round of briefings surrounding that before intervention is granted. For example, when DOJ intervened in the Tennessee lawsuit challenging their anti-trans care ban, there was briefing back and forth on that before they were granted intervention. So, I mean, that took, I think, like 2 months. So this is something that could be going on into the new year before they're granted intervention.
So does it mean that Scopes is probably going to be pushing and thinking about pushing before they
I
take
gave
the case?
in my post at LAW Dork, I basically said there are 4 options. They could say full steam ahead, nothing has changed technically at this point, so we are going to take the case as we got it. I don't think that's likely because of the fact that, like, if they took the case, have all the briefing, and then dismiss it on standing, they haven't resolved the question if these AGs get standing in the interim.
Oh my God.
Because the case would still exist.
Right.
So I don't think they'll do that. They could just dismiss the cert petitions, which would in effect allow the Fifth Circuit ruling to go into effect. So I think that's extremely unlikely in light of the fact that they issued this stay pending cert. And that it would just be an absolutely batshit move for even this court to do without hearing a case.
Right.
The next option would be to just hold the petitions. They could hold them until there's a ruling on intervention, but that doesn't really buy you much because, like I said, the intervention's likely. The rules for intervention, especially permissive intervention, are pretty light, given that these are people who do have different interests, who can argue for their reasons for coming into the case. But I should note, I mean, and because it is Kaczmarek, let's be honest, I should note, remember there's the Washington versus FDA case. There's the sort of companion
Case, right.
Democratic AG case.
We can't hear you, Liz.
Audio's off.
We can't hear you, Liz. Can't hear you. Still can't hear you. But yes, I remember that case.
Yeah. I mean, so that case is still pending. But I would note Republican AGs did move to intervene in that case and were denied at the district court level, because he basically said, you have no real interests that you're claiming. Like they're bringing a lawsuit about protecting their residents' rights to have access to this drug. So you have no interest in this case. That's a little different than this intervention. So you've got all this pending. So they could hold it until intervention is granted. They could also hold it until if Kaczmarek grants these AGs a preliminary injunction. If that happens, like we're talking about a long wait. I think that would take a long time if it goes through the Fifth Circuit, but there is a way to sort of short circuit that. He could issue he could grant intervention, he could issue a preliminary injunction, and then DOJ could file for a thing called cert before judgment. And that's asking for a cert petition, but it's basically asking to leapfrog the appeals court. And while the Supreme Court disfavors that, if there's these other cert petitions pending, they might say that's fine. A notable example of when that happened in the past was the DOMA cases. Edie Windsor's case was a cert before judgment. There was no Second Circuit decision before they filed their cert petition. So it does happen, and it does happen in these sorts of instances where there are already other cases waiting. So that would be a way, but it would delay things definitely into next term. It wouldn't happen this term. So it would mean the arguments would probably be next October or November of 2024.
Which means a decision maybe in 2025.
But also October 2024 feels really good for us.
Right. Yeah, that's why I'm saying I don't know if Chris Kobach and Labrador and Bailey really care about the national implications. The fourth option is, I do want to say it because it's a little wild, but it's also, if it happens, I want to have been on record that it could happen. They could, if they really want to. I've been writing about this idea that like the Supreme Court can actually use the Fifth Circuit to regain institutional authority by sort of knocking down, sort of doing the same thing we were talking about with the jokes, Liz. They can knock down the really batshit rulings while still allowing some of the crazy stuff to come up. And so they can still be moving the law to the right consistently while maintaining institutional integrity by tossing out the really batshit stuff. And so what they could do is this thing called summary reversal. And it is like, it's the smackdown. It's the SCOTUS smackdown. What you do is you say, this is so clearly wrong. We don't need to hear arguments in the case. We're going to, it's called GVR in our like SCOTUS dork terms, grant, vacate, remand. What you do is all in one fell swoop, you grant the cert petition, you vacate the lower decision, and you send it back to the appeals court. And normally there's like a paragraph of instructions that basically says, what were you thinking? Like, get it together. And like normally it says like, reconsider this in light of X. And normally the like not smackdown version where you see summary reversals and GVRs is when the Supreme Court has like cases that cert petitions have come up on a topic while they're hearing another case that involves the same thing. And they issue their decision, and then they look at all the cases that present similar issues and they GVR them. They say, okay, we're taking all of these cases because there are bad decisions below. We're vacating the lower decisions, and you should reconsider them in light of this new decision. But what they could do here is grant, vacate, remand, and say, this standing ruling of the Fifth Circuit is so far outside of our precedent. They just cite to an earlier standing precedent and say, reconsider this, more closely paying attention to the rules in X. And what that would do is allow, what if they do that, what they could be doing is saying, we don't want to consider this more on a preliminary injunction. We want you to do this. If you're going to do this, Kaczmarek, you're going to grant intervention, do this with all of these parties and give us a final judgment so that we can resolve this for once and for all. Makes sense. But they would also like probably like if they did that, they would issue like they would be vacating the injunction, and they would basically be sending a strong sign like, you're not getting rid of this in total. Like, so like,
tone it down.
Don't make us go back up again with this, because we will.
Right.
So that would actually, in some ways, that would be the cleanest way of dealing with this, so that there's like not just like doubt pending, but I don't. I think that either, but that would require 5 votes.
Right.
I mean,
Wow.
that would require like, I mean, basically, it would require Kavanaugh to join the Chief Justice and the 3 Democrats.
That is a lot, Chris. So we have a lot to chew on here. We have to wrap it up.
Yeah.
But when they finally bring this ruling, will you come back and talk with us either on the podcast or here? Because I feel like now that you're our Instagram buddy, you're
Yes.
gonna be our go-to friend on all these things.
No, yeah.
We need people to know the Law Dork. The Law Dork, the Law Dork, the Law Dork. Thank you for joining us and laying this out, because it just feels, I think it's really good for people to hear how fragmented and wild things can get, and what we're dealing with our rights.
Yeah, it truly is. But just before we go, I do like, the bottom line is the Supreme Court, this Supreme Court has made very clear that until it is able to hear a case about this, it is maintaining Mifepristone's accessibility on the current terms, not only the 2000 approval, but also the 2016 eased access and the 2021 and 23 eased access, and obviously the generic approval. Like that is an important thing to note in light of this Supreme Court.
You know what? Like, that is, so that gives us a kernel of hope. I feel a kernel of hope.
I mean, because that, like, all of these things we're talking about waiting, like, in some ways, if you're talking about harm reduction principles, like, which is something that, like, Chase Strangio is always talking about with me when we're talking about trans care, like, that is a very good harm reduction principle.
Yes.
It's just there. And the court has made it clear that they're very uncomfortable with these rulings below.
Oh my God, Chris, thank you. People in the comments are so grateful for you and for your explaining, and they're so excited. Look, here's the thing about Law Dork and about Chris Geidner. When 24-hour news focuses on 2 things in the world, elections, what's happening in the Middle East, very important. Our world, you need to be educated on what is happening, and it's independent media that is bringing you that. And Chris does an incredible job of bringing you what's happening with your rights at the highest courts, so you can understand and learn how to advocate. So please, please, please subscribe to Law Dork on Substack. Give him money. Do it, because it's these kind of journalists that can help all of us be smarter so we can advocate harder. Thank you, Chris.
Thank you, Chris.
Thank you both.
Bye.
Great to meet you.
Great to meet you. Bye.
Bye.